Greetings, class. This is the last one of the recordings on the initial chapters relating to contracts. And this one specifically focuses on consideration, which is the last part of chapter 10. So what is consideration? Well, consideration is the basis of the bargain. Courts typically, in order to have a binding contract, enforce promises that have value. That value doesn't necessarily have to be economic value. It could be intangible. So if you look at the pictures that I have here, I have a figure with money. And of course, when we think of economic value, we often think of money, but it could be property. It doesn't have to be money per se. And it can be intangible. And so on the right side of the slide, I have stick figures that are holding up signs to protect their rights. And the idea is that I'm trying to represent here is that consideration could involve giving up something that you have the right to do. So we'll start with this example. Stan, Art, Jill, and Paula have been assigned a group project. This may sound familiar to you. They promise to meet in the library each Thursday to divide tasks and discuss their progress. Jill attends the first 2 meetings and fails to attend any others. The project is due in 2 weeks. Has Jill made a legally enforceable promise? And I want you to think about that for just a minute. I know many of you have been in this situation where you have group projects, including in my class. You're not meeting in person, but you're meeting online. Is that a legally enforceable promise? And the answer is no. It's not a legally enforceable promise. Consideration does involve a bargain for exchange of something of value. So Jill promises to meet in the library each Thursday to divide tasks and discuss their progress. Is that something of value? No, not really. The law generally focuses on economic type value, though she is giving up her right to not meet and to go somewhere else. But on the other hand, I don't know, she's not giving up so much, because she has a responsibility to study and do the group work and be prepared. But also, so, there'd be questionable argument about whether this is of economic value. And then the second part is, were the parties bargaining for this promise? And clearly the answer here is no. This wasn't a contractual situation. It was a situation where the parties had responsibilities to get their schoolwork done, and Jill was supposed to be participating in that. So they weren't negotiating, they were just setting up the schedule for completing the project. And so for both of those reasons, she has not made a legally enforceable promise. So, as I mentioned, consideration is a bargain for a waiver or promised waiver of rights, and that was that picture that the people holding the sign up, incurring a legal detriment. And the detriment is just that you give up something. You can give up those rights, you could give up money, but you give up something, give up property. It's different than motive. So consideration is different than why you're doing something. The why isn't the contract. The part of the contract, the consideration part of the contract is what you give up. And then it's part of an exchange of promises, or a promise in exchange for an act or not acting. And those are the things, the components that make something consideration. So let's see how you do on answering this question. The common law contract doctrine of consideration, A, requires that consideration have a monetary value if it is to be valid. B, recognizes that forbearance from a legal right constitutes consideration. C, has been abolished in most jurisdictions if the contract is made under seal. And D, requires a roughly equal exchange of value by the parties to the contract. So, think about it. What is the correct answer here? Pause the video, think about it. The answer is B. The common law contract doctrine of consideration recognizes that the forbearance from a legal right constitutes consideration, giving up something, giving up the right to sue, for example. That's a common example of consideration. A is incorrect because consideration doesn't have to have a monetary value. It can have an economic value, but that's not necessarily a dollar value. Consideration hasn't been abolished. It's a key part of a contract. And note that D is not correct. D says it requires a roughly equal exchange of value. It does not. That's not what consideration is. Consideration is just each party giving up something, exchanging, giving up something. And that's what consideration is. So, true or false, a promise to provide services at your request consists of consideration for a payment of $10. So the picture here that I have on this slide is of a robot that's providing a service, right? Is holding a serving tray covered and has a towel on its arm, so it's providing a service. True or false? Is a promise to provide services at your request consists of consideration for a payment of $10. Is that true or not? Pause. Okay, hopefully you paused. And the answer is that it's false. Consideration requires that each party incur a legal detriment. That means both parties have to give up something, whether it's an action they give up or whether it's a promise to act or not act that they give up. Here, the person promising to provide services at your request hasn't made a commitment. A party could request nothing, and that would be okay. There's no violation. And in order to be consideration, the promise must be a commitment that provides a legal detriment. And just saying at your request is probably not enough. So the next review question is, an uncle promises in writing to give his nephew $5,000 on his 18th birthday. The nephew's made great plans for this money, including a contract for an expensive camera he's always wanted. Then during the 18th birthday celebration, the uncle is offended by the nephew's drinking. The uncle tears up the $5,000 check he was about to deliver to his nephew. Is his nephew entitled to the money? Okay, read it. Think about it. Pause the video. Jot down an answer. So, is the nephew entitled to the money? No. The nephew hasn't incurred a legal detriment. So what did he do? He turned 18. Turning 18 or getting older is not consideration. He didn't give up anything. The nephew didn't give up anything. Now, some people look at this and say that the nephew had made plans for the money, including a contract for an expensive camera he'd always wanted, and wonder if promissory estoppel would apply. It doesn't. It doesn't apply because the uncle didn't promise to give the $5,000 so that the nephew could buy a camera. In other words, the uncle did not make the promise in order to get the nephew to make a commitment to buy the camera. That wasn't the purpose of the promise. The uncle promised to give a gift. And a promise to give a gift, except in the case of charitable subscriptions, that's discussed later in the book, a promise to give a gift is not a legally enforceable promise. So the nephew hasn't done anything to get the money, and so he can't. Now, in addition to looking at how consideration is defined and giving you some examples of where consideration exists or doesn't, there are some issues that relate to consideration. And one of the common issues is what happens if the consideration is inadequate? It's not enough, right? That's what inadequate, the consideration's not enough. And the answer is you're stuck if you made a bad bargain. So this image I have on the slide is, the stick figure holding its head as if to say, oh man, I wish I hadn't done that. I didn't like it. I'm not getting what I wanted. The courts generally leave you where they find you. If you make a bad bargain, you're stuck with it. The example is buyer's remorse. If you buy something and the next day you decide, oh man, I really didn't want this, you have no recourse. Another issue that another issue that arises with consideration is the issue of firm offers. Firm offers, which are UCC Article 2, and there are several characteristics of the firm offers, including has to be a contract for the sale of goods. The parties have to be merchants, which are experts, and has to be assigned writing. If there's a firm offer, that means the merchant is saying, okay, you want to buy this television, buyer, and the merchant then puts in assigned writing that the merchant will sell the television to the buyer at a set price and leaves that offer open for a period of time. That's what a firm offer is. There's no consideration required for that firm offer to be binding on the merchant. And this is an example of where Article 2 is different than the common law. The common law says if you give an option or an option contract, then there has to be money to hold it open. So if I give you another example, I offer to mow your lawn for $50. And you're not sure whether you want me to mow the lawn or not. So I say, well, look, I'll hold that offer to mow it for $50. I'll hold it open till Sunday, and then you can decide. And you're the other party. You say, oh, thanks. That'll give me time to think about it. And then one of your friends comes along and says, you know what? I'll mow your lawn for $30. Then, and so you contact me and say, you know what? I've changed my mind. I have no recourse against you, even if it's before Sunday, unless there's money paid to hold it open till Sunday. Then that's a different situation. So take a look at that in the book, but that's the distinction between firm offers and options or option contracts. Now, another issue, if I can get it to, okay. Let's see, it won't move. So let's go to the next slide. No, it won't go to the next slide. Okay, there we are. So the next issue that arises with consideration is distinguishing liquidated from unliquidated debts. And this gets a little complicated, so I'm hoping these diagrams will help you understand it. First of all, if you look at it, a liquidated debt is a debt where the amount is settled. And that's what the handshake, the figure is shaking hand, that means that they already know what the amount is that's due. So I buy a television from you. The total price, including finance charge, is $1,000. I make my payments, and then for some reason I don't make the $200 remaining payments. I pay the first $800 and then I stop. That's a liquidated debt. And it's liquidated because I know I owe you $200. I know the contract provides that I owe you $200. I just haven't paid it. If you have a liquidated debt, then an accord and satisfaction for less is not binding. Why? Because I haven't given up anything. If I talk to you and I say, you know I owe you $200, but I could give you $150 and I'll be done with it. And even if you say yes, because it's a liquidated debt, it's not a binding contract. Why? Because I haven't given up anything. I owed $200. I am paying $150. You, the other party, are giving up $50, but you're not getting anything special from me. So the accord and satisfaction is not going to be binding unless there's something additional paid. So if, for example, I say, well, I'll pay you $150, plus I'll give you this autographed CD of me singing, assuming I have one, then that would be enough to settle it because that's additional consideration. but otherwise, that accord and satisfaction for less is not binding. So that's what that diagram on the left is. Now on the right, we have an unliquidated debt. And an unliquidated means it's disputed. That means the parties aren't in agreement. So you can see on the diagram, I have a circle with a line through it, signifying that there's no agreement between the parties on how much is owed. If there's a disagreement, and then the parties sign an accord and satisfaction or reach an accord and satisfaction, that is binding on the parties. Why? Because each party gives up something. So if we take the example where I'm buying the television for $1,000, I pay the first $800, and then there's a problem, and let's assume it's a genuine problem. It's not something I made up. There's a genuine problem, and I say, you know what? The HD channels don't come in as HD anymore. They used to, and now they don't. So I think the TV is really worth only $800, and that's all I'm going to pay you. And then you, the seller, say, well, you owe me $1,000, and I expect to get $1,000, and we discuss it, and finally you as a seller say, you know what, I'll just take $900 and we'll just call it even. And I say, okay, fine, I'll pay you another 100 and then we'll call it even. That's an accord, and then if I pay you the 100, that's the satisfaction. That is binding because we had an unliquidated debt. We had an unsettled, we had a disputed debt. And where there's a dispute, and then you settle it, each person's giving up something. Okay, that was my doorbell. Just a minute. Okay, sorry about that. So I was talking about the unliquidated debt. And with the unliquidated debt, that means that there's a dispute about the amount that's owed. So in the case of I bought the TV for $1,000, I paid $800 of it, and then I complained about not getting the HD channels, and you say I owe $1,000. You as a seller say I owe $1,000, but you'll take $900, and then I pay the $900. That's an accord and satisfaction. That is binding on both of us. And the reason is because each of us is giving up something. I'm giving up the right to go to court, get the dispute resolved, and possibly pay $800 or something less than $900. And you, the seller, are giving up something because you're giving up your right to go to court and have me pay $950 or $1,000, the full amount. So when each party gives up something and then they reach an accord and a satisfaction, then that's binding. So that's the distinction between liquidated and unliquidated debts. So go back and review that in the book, and hopefully that'll help make it clearer for you. In terms of composition of creditor agreements, just go ahead and read that. Normally, an accord and satisfaction for less isn't binding when there's an agreement on what's due, but if a group of creditors get together and agree to take less, then that's binding. So just read that in the book. So let's go through a few questions. Vang entered into a contract with Sammy to purchase a bicycle for $100 and later learned that the bicycle was worth $25. True or false, Vang can successfully sue to rescind the contract for inadequacy of consideration. So think about it, and then I'll go to the next slide. The answer is false. Vang cannot successfully sue. Why is that? Because this is a case of adequacy of consideration. Vang is saying that she paid too much for the bicycle. That it was really worth $25 and she paid $100. If the consideration is inadequate, the courts don't step in, with some exceptions where there's an extreme difference in price, so extreme that it's as though one is taking advantage of another. And this difference is not enough. Okay, the next question. Cam, a police officer, provided information that resulted in apprehension of a fugitive. True or false? Cam would be entitled to any reward that had been posted for providing information about that fugitive if she knew about the reward. Take a minute to think about it. Pause. Okay, and then the answer is false. Cam isn't entitled to a reward. Why? Because police officers have a pre-existing duty to provide information to apprehend a fugitive. So Cam didn't give up anything. There's no consideration, right? Cam had a pre-existing duty, and since she had a pre-existing duty, then giving the information, she's not doing anything she didn't already have an obligation to do. So no consideration. Third question, Abdul made a 1-year written contract with Sarah whereby Abdul agreed to mow Sarah's lawn weekly for $150 per month. Sarah called him and told him she wanted him to mow the lawn bi-weekly instead for $75 per month. Abdul agreed. True or false, Abdul is bound to comply with the modified contract. Think about it. Pause. You've thought about it. This is false. The question is whether Abdul agreed, then he changed his mind. So is he bound to comply? No, he's not. This is not a UCC contract. If it was a UCC goods contract between merchants, you could have a firm offer or something. That doesn't apply here. Or a good faith modification, none of that applies here because it's a service contract. In this case, he already had a binding contract. The contract was for the set term or set amount per month. He's not bound to comply with it because he gave up something, but she didn't give up anything. So, while working on his car, Aaron found his neighbor at his side. The neighbor solved the problem, and Aaron said, "I'm going to give you $50 when I get paid." Then when payday arrives, Aaron tells the neighbor he's changed his mind. Does the neighbor have any legal recourse? Pause for a moment. Think about your answer. The neighbor doesn't have any legal recourse. This was past consideration or moral consideration, neither of which is legally sufficient consideration. So, past consideration, next payday I'm going to give you $50. The neighbor had already done the work, and then Aaron made the promise. So there wasn't a bargain for exchange, right? One happened first, and then he made a promise. Also, moral consideration, Aaron's acting out of gratitude, and gratitude is not legally sufficient consideration for a contract. The book mentions some other things that where consideration is lacking, some other situations. I'm not going through all of them, although I touched on some already in going through the review questions. Illusory promises, just look that up so you know what that means. Pre-existing duty under a contract modification requires consideration, except under UCC where it can just be good faith. Be sure you look at that and make sure that you understand that. The statutory or contractual duty, I've already reviewed in the context of the police officer example. And then moral consideration and past consideration, I reviewed in, I think that was question 4, the last question. So again, you need to go back and look at the book, but this just gives you a kind of guide to studying. So I want to make one more point or summary of points about consideration, and then I'll be finished. So consideration is not required if, in the case of promissory estoppel, which is an equitable doctrine, be sure to read through it. There are several elements of it. Charitable subscriptions, where a charity relies on someone's promise to make donations over a period of time, and that can be binding. Promises made after the statute of limitations expires, and promises to pay debts covered by bankruptcy discharge, as long as the promisor fulfills the requirements under the bankruptcy law, then that can still be binding even if there's no consideration. So that's a summary of the information for chapters 9 and 10, and I'll continue to work on providing more of these. Okay, have a great day.